Please be seated. The sitting is open. The court meets today to deliver in open court its decision on the request for indication of provisional measures submitted by South Africa in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip, South Africa versus Israel. Judge Robinson, who duly participated in both the deliberation and the final vote, is, for reasons made known to me, unable to take his seat on the bench today. I would like to welcome the eminent representatives of the Republic of South Africa and the State of Israel who are in the Great Hall of Justice today. In particular, I recognize the presence of Her Excellency, Ms. Naledi Pandor, Minister of International Relations and Cooperation of the Republic. Reservations have been adopted by the General Assembly and the Security Council of the United Nations, referring to many aspects of the conflict. The scope of the present case submitted to the court, however, is limited, as South Africa has instituted these proceedings under the Genocide Convention. The court then turns to the conditions needed to be fulfilled in order for it to indicate provisional measures. With respect to the question of prima facie jurisdiction, the court observes that it may indicate provisional measures only if the provisions relied on by the applicant appear prima facie to afford a basis on which its jurisdiction could be founded, but it need not satisfy itself in a definitive manner that it has jurisdiction as regards the merits of the case. In the present case, South Africa seeks to found the jurisdiction of the court on Article 36, Paragraph 1 of the Statute of the Court and on Article 9 of the Genocide Convention. The court must therefore first determine whether those provisions prima facie confer upon it jurisdiction to rule on the merits of the case, enabling it, if the other necessary conditions are fulfilled, to indicate provisional measures. Article 9 of the Genocide Convention provides, I quote, disputes between the contracting parties relating to the interpretation, application, or fulfillment of the present convention, including those relating to the responsibility of a state for genocide or for any of the other acts enumerated in Article 3, shall be submitted to the International Court of Justice at the request of any of the parties to the dispute, end of quote. South Africa and Israel are both parties to the Genocide Convention, and neither of them has entered a reservation to Article 9 or any other provision of the Convention. The court then recalls that Article 9 of the Genocide Convention makes its jurisdiction conditional on the existence of a dispute relating to the interpretation, application, or fulfillment of the Convention. A dispute is a disagreement on a point of law or fact, a conflict of legal views or of interest between parties. In order for a dispute to exist, it must be shown that the claim of one party is positively opposed by the other. The two sides must hold clearly opposite views concerning the question of the performance or non-performance of certain international obligations. To determine whether a dispute exists in the present case, the court cannot limit itself to noting that one of the parties maintains the convention applies while the other denies it. Since South Africa has invoked as a basis for the court's jurisdiction the compromissory clause of the Genocide Convention, the court must also ascertain at the present stage of the proceedings whether it appears that the acts and omissions complained of by the applicant are capable of falling within the scope of that convention, ratio materi. The court recalls that for purposes of deciding whether a dispute existed between the parties at the time of the filing of the application, it takes into account, in particular, any statements or documents exchanged between the parties, as well as any exchanges made in multilateral settings. In so doing, it pays special attention to the author of the statement or document, its intended or actual addressee, and its content. The existence of a dispute is a matter for objective determination by the court. It is a matter of substance, not a question of form or procedure. The court notes that South Africa issued public statements in various multilateral and bilateral settings in which it expressed its view that, in light of the nature, scope, and extent of Israel's military operations in Gaza, Israel's actions amounted to violations of its obligations under the Genocide Convention. For instance, at the resumed 10th Emergency Special Session of the United Nations General Assembly on 12 December 2023, at which Israel was represented, the South African representative to the United Nations stated that, I quote, "The events of the past 6 weeks in Gaza have illustrated that Israel is acting contrary to its obligations in terms of the Genocide Convention." End of quote. South Africa recalled this statement in its note verbal of 21 December 2023 to the Embassy of Israel in Pretoria. The court notes that Israel dismissed any accusation of genocide in the context of the conflict in Gaza in a document published by the Israeli Ministry of Foreign Affairs on 6 December 2023, which was subsequently updated and reproduced on the website of the Israel Defense Forces on 15 December 2023 under the title, "The War Against Hamas, Answering Your Most Pressing Questions," stating that, I quote, "The accusation of genocide against Israel is not only wholly unfounded as a matter of fact and law, it is morally repugnant." End of quote. In the document, Israel also stated that, I quote, "The accusation of genocide is not just legally and factually incoherent, it is obscene, and that there was no valid basis in fact or law for the outrageous charge of genocide." End of quote. In light of the foregoing, the court considers that the parties appear to hold clearly opposite views as to whether certain acts or omissions allegedly committed by Israel in Gaza amount to violations by the latter of its obligations under the Genocide Convention. The court finds that the aforementioned elements are sufficient at this stage to establish prima facie the existence of a dispute between the parties relating to the interpretation, application, or fulfillment of the Genocide Convention. As to whether the acts and omissions complained of by the applicant appear to be capable of falling within the provisions of the Genocide Convention, the court recalls that South Africa considers Israel to be responsible for committing genocide in Gaza and for failing to prevent and punish genocidal acts. South Africa contends that Israel has also violated other obligations under the Genocide Convention, including those concerning conspiracy to commit genocide, direct and public incitement to genocide, attempted genocide, and complicity in genocide. At the present stage of the proceedings, the court is not required to ascertain whether any violations of Israel's obligations under the Genocide Convention have occurred. Such a finding could only be made by the court at the stage of the examination of the merits of the present case. At the stage of making an order on the request for an indication of provisional measures, the court's task is to establish whether the acts and omissions complained of by the applicant appear to be capable of falling within the provisions of the Genocide Convention. In the court's view, at least some of the acts and omissions alleged by South Africa to have been committed by Israel in Gaza appear to be capable of falling within the provisions of the Convention. In light of the following, the court concludes that, prima facie, it has jurisdiction pursuant to Article 9 of the Convention to entertain the case. Given this conclusion, the court considers that it cannot accede to Israel's request that the case be removed from the general list. The court turns next to the question of standing of South Africa. Court notes that the respondent did not challenge the standing of the applicant in the present proceedings. In the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide, the Gambia v. Myanmar, where Article 9 of the Genocide Convention was also invoked, the court observed that all states parties to the convention have a common interest to ensure the prevention, suppression, and punishment of genocide by committing themselves to fulfilling the obligations contained in the convention. Such common interest implies that the obligations in question are owed by any state party to all the other state parties to the relevant convention. They are obligations erga omnes partes, in the sense that each state party has an interest in compliance with them in any given case. The common interest in compliance with the relevant obligations under the Genocide Convention entails that any state party, without distinction, is entitled to invoke the responsibility of another state party for an alleged breach of its obligations erga omnes partes. Accordingly, the court found that any state party to the Genocide Convention may invoke the responsibility of another state party, including through the institution of proceedings before the court, with a view to determining the alleged failure to comply with its obligations erga omnes partes under the convention, and to bringing a failure to the end. The court concludes prima facie that South Africa has standing to submit to it the dispute with Israel concerning alleged violations of obligations under the Genocide Convention. The court then turns to the question of the rights whose protection is sought and the link between such rights and the measures requested. It recalls that its power to indicate provisional measures under Article 41 of the statute has as its object the preservation of the respective rights claimed by the parties in a case, pending its decision on the merits thereof. It follows that the court must be concerned to preserve by such measures the rights which may subsequently be adjudged by it to belong to either party. Therefore, the court may exercise this power only if it is satisfied that the rights asserted by the party requesting such measures are at least plausible. At this stage of the proceedings, however, the court is not called upon to determine definitively whether the rights which South Africa wishes to seek protected exist. It need only decide whether the rights claimed by South Africa and for which it seeks protection are plausible. Moreover, a link must exist between the rights whose protection is sought and the provisional measures being requested. The court recalls that in accordance with Article 1 of the Convention, all states parties thereto have undertaken to prevent and to punish the crime of genocide. Article 2 provides that, I quote, genocide means any of the following acts committed with an intent to destroy in whole or in part a national, ethnical, racial, or religious group as such. A, killing members of the group. B, causing serious bodily or mental harm to members of the group. C, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. D, imposing measures intended to prevent births within the group. E, forcibly transferring children of the group to another group. End of quote. Pursuant to Article 3 of the Genocide Convention, the following acts are also prohibited by the Convention: conspiracy to commit genocide, direct and public incitement to commit genocide, attempt to commit genocide, and complicity in genocide. The provisions of the Convention are intended to protect the members of a national, ethnical, racial, or religious group from acts of genocide or any other punishable acts enumerated in Article 3. The court considers that there is a correlation between the rights of members of groups protected under the Genocide Convention, the obligations incumbent on state parties thereto, and the right of any state party to seek compliance therewith by another state party. As the court has stated in other cases, in order for acts to fall within the scope of Article 2 of the Convention, the intent must be to destroy at least a substantial part of a particular group. This is demanded by the very nature of the crime of genocide, since the object and purpose of the Convention as a whole is to prevent the intentional destruction of groups. The part targeted must be significant enough to have an impact on the group as a whole. The Palestinians appear to constitute a distinct national, ethnical, racial, or religious group, and hence a protected group within the meaning of Article 2 of the Genocide Convention. The court observes that, according to United Nations sources, the Palestinian population in the Gaza Strip comprises over 2 million people. Palestinians in the Gaza Strip form a substantial part of the protected group. The court notes that the military operation being conducted by Israel following the attack of 7 October 2023 has resulted in a large number of deaths and injuries, as well as massive destruction of homes, the forcible displacement of the vast majority of the population, and extensive damage to civilian infrastructure. While figures relating to the Gaza Strip cannot be independently verified, recent information indicates that 25,700 Palestinians have been killed, over 63,000 injuries have been reported, over 360 housing units have been destroyed or partially damaged, and approximately 1.7 million persons have been internally displaced. The court takes note in this regard of the statement by the United Nations Undersecretary General for Humanitarian Affairs and Emergency Relief Coordinator, Mr. Martin Griffiths, on 5 January 2024. I quote, "Gaza has become a place of death and despair. Families are sleeping in the open as temperatures plummet. Areas where civilians were told to relocate for their safety have come under bombardment. Medical facilities are under relentless attack. A public health disaster is unfolding. Gaza has simply become uninhabitable. Its people are witnessing daily threats to their very existence while the world watches on." End of quote. Following a mission to North Gaza, the World Health Organization reported that as of 21 December 2023, I quote, "An unprecedented 93% of the population of Gaza is facing crisis levels of hunger with insufficient food and high levels of malnutrition." End of quote. The court further notes the statement issued by the Commissioner General of the United Nations Relief and Works Agency for Palestine Refugees in the Near East, or UNRWA, Mr. Philippe Lazzarini, on 13 January 2024. I quote, "It's been 100 days since the devastating war started, killing and displacing people in Gaza following the horrific attacks that Hamas and other groups carried out against people in Israel. It's been 100 days of ordeal and anxiety for hostages and their families. In the past 100 days, sustained bombardment across the Gaza Strip caused the massive displacement of a population that is in a state of flux, constantly uprooted and forced to leave overnight, only to move to places which are just as unsafe. This war affected more than 2 million people, the entire population of Gaza. Many will carry lifelong scars, both physical and psychological. The vast majority, including children, are deeply traumatized. Overcrowded and unsanitary UNRWA shelters have become home to more than 1.4 million people. They lack everything, from food to hygiene to privacy. People live in inhumane conditions where diseases are spreading, including among children. They live through the unlivable with the clock ticking fast towards famine. The plight of children in Gaza is especially heartbreaking. An entire generation of children is traumatized and will take years to heal. Thousands have been killed, maimed, and orphaned. Hundreds of thousands are deprived of education. Their future is in jeopardy with far-reaching and long-lasting consequences. The UNRWA Commissioner General also stated that the crisis in Gaza is, I quote, "compounded by dehumanizing language," end of quote. In this regard, the court has taken note of a number of statements made by senior Israeli officials. It calls attention in particular to the following examples. On 9 October 2023, Mr. Yoav Gallant, Defense Minister of Israel, announced that he had ordered a complete siege of Gaza City, and then that there would be no electricity, no food, no fuel, and that everything was closed. On the following day, Minister Gallant stated, speaking to Israeli troops on the Gaza border, I quote, "I have released all restraints. You saw what we are fighting against. We are fighting human animals. This is the ISIS of Gaza. This is what we are fighting against. Gaza won't return to what it was before. There will be no Hamas. We will eliminate everything. If it doesn't take one day, it will take a week. It will take weeks or even months. We will reach all places." End of quote. On 12 October 2023, Mr. Isaac Herzog, President of Israel, stated, referring to Gaza, I quote, We are working, operating militarily according to rules of international law, unequivocally. It is an entire nation out there that is responsible. It is not true, this rhetoric about civilians not aware, not involved. It is absolutely not true. They could have risen up. They could have fought against that evil regime which took over Gaza in a coup d'etat. But we are at war. We are at war. We are at war. We are defending our homes. We are protecting our homes. That's the truth. And when a nation protects its home, it fights. And we will fight until we break their backbone. End of quote. On 13 October 2023, Mr. Israel Katz, then Minister of Energy and Infrastructure of Israel, stated on X, formerly Twitter, I quote, "We will fight the terrorist organization Hamas and destroy it. All the civilian population in Gaza is ordered to leave immediately. We will win. They will not receive a drop of water or a single battery until they leave the world." End of quote. The court also takes note of a press release of 16 November 2023, issued by 37 special rapporteurs, independent experts, and members of working groups part of the special procedures of the United Nations Human Rights Council, in which they voiced alarm over, I quote, "discernibly genocidal and dehumanizing rhetoric coming from senior Israeli government officials." End of quote. In addition, on 27 October 2023, the United Nations Committee on the Elimination of Racial Discrimination observed that it was highly concerned about the sharp increase in racist hate speech and dehumanization directed at Palestinians since 7 October. In the court's view, the aforementioned facts and circumstances are sufficient to conclude that at least some of the rights claimed by South Africa and for which it is seeking protection are plausible. This is the case with respect to the right of Palestinians in Gaza to be protected from acts of genocide and related prohibited acts identified in Article 3, and the right of South Africa to seek Israel's compliance with the latter's obligations under the Convention. The court then turns to the condition of the link between the plausible rights claimed by South Africa and the provisional measures requested. It considers that by their very nature, at least some of the provisional measures sought by South Africa are aimed at preserving the plausible rights it asserts on the basis of the Genocide Convention in the present case, namely, the right of the Palestinians in Gaza to be protected from acts of genocide and related prohibited acts mentioned in Article 3, and the right of South Africa to seek Israel's compliance with the latter's obligations under the Convention. Therefore, a link exists between the rights claimed by South Africa that the court has found to be plausible and at least some of the provisional measures requested. The court turns next to the question of risk of irreparable prejudice and urgency. It notes that, pursuant to Article 41 of its statute, it has the power to indicate provisional measures when irreparable prejudice could be caused to rights which are the subject of judicial proceedings, or when the alleged disregard of such rights might entail irreparable consequences. However, the power of the court to indicate provisional measures will only be exercised if there's urgency in the sense that there is a real and imminent risk that irreparable prejudice will be caused to the rights claimed before the court gives its final decisions. The condition of urgency is met when the acts susceptible of causing irreparable prejudice can occur at any moment before the court makes the final decision in the case. The court must therefore consider whether such a risk exists at this stage of the proceedings. The court is not called upon for purposes of its decision on the request for the indication of provisional measures to establish the existence of breaches of obligations under the Genocide Convention, but to determine whether the circumstances require the indication of provisional measures for the protection of rights under that instrument. As already noted, the court cannot at this stage make definitive findings of fact, and the right of each party to submit arguments with respect to the merits remains unaffected by the court's decision on the request for the indication of provisional measures. The court recalls that, as underlined in General Assembly Resolution 96-1 of 11 December 1946. I quote, "Genocide is a denial of the right of existence of entire human groups, as homicide is the denial of the right to live of individual human beings. Such denial of the right of existence shocks the conscience of mankind, results in great losses to humanity in the form of cultural and other contributions represented by these human groups, and is contrary to moral law and to the spirit and aims of the United Nations." End of quote. In view of the fundamental values sought to be protected by the Genocide Convention, the court considers that the plausible rights in question in this proceeding, namely, the right of Palestinians in the Gaza Strip to be protected from acts of genocide and related prohibited acts identified in Article 3 of the Genocide Convention, and the right of South Africa to seek Israel's compliance with the latter's obligation under the Convention, are of such a nature that prejudice to them is capable of causing irreparable harm. During the ongoing conflict, senior United Nations officials have repeatedly called attention to the risk of further deterioration of conditions in the Gaza Strip. The court takes note, for instance, of the letter dated 6 December 2023, whereby the Secretary General of the United Nations brought the following information to the attention of the Security Council. I quote, "The healthcare system in Gaza is collapsing. Nowhere is safe in Gaza. Amid constant bombarding by the Israel Defense Forces and without shelter or the essentials to survive, I expect public order to completely break down soon due to the desperate conditions rendering even limited humanitarian assistance impossible. An even worse situation could unfold, including epidemic diseases and increased pressure for mass displacement into neighboring countries. We are facing a severe risk of collapse of the humanitarian system. The situation is fast deteriorating into a catastrophe with potentially irreversible implications for Palestinians as a whole and for peace and security in the region. Such an outcome must be avoided at all costs." End of quote. On 5 January 2024, the Secretary General wrote again to the Security Council, providing an update on the situation in the Gaza Strip and observing that, I quote, "Sadly, devastating levels of death and destruction continue." End of quote. The court also takes note of the 17 January 2024 statement issued by the UNRWA Commissioner General upon return from his fourth visit to the Gaza Strip since the beginning of the current conflict in Gaza. I quote, "Every time I visit Gaza, I witness how people have sunk further into despair, with the struggle for survival consuming every hour." End of quote. The court considers that the civilian population in the Gaza Strip remains extremely vulnerable. It recalls that the military operation conducted by Israel after 7 October 2023 has resulted inter alia in tens of thousands of deaths and injuries and the destruction of homes, schools, medical facilities, and other vital infrastructure, as well as displacement on a massive scale. The court notes that the operation is ongoing and that the Prime Minister of Israel announced on 18 January 2024 that the war, I quote, "will take many more long months." End of quote. At present, many Palestinians in the Gaza Strip have no access to the most basic foodstuffs, potable water, electricity, essential medicines, or heating. The World Health Organization has estimated that 15% of the women giving birth in Gaza Strip are likely to experience complications and indicates that maternal and newborn death rates are expected to increase due to the lack of access to medical care. In these circumstances, the court considers that the catastrophic humanitarian situation in the Gaza Strip is at serious risk of deteriorating further before the court renders its final judgment. The court recalls Israel's statement that it has taken certain steps to address and alleviate the conditions faced by the population in the Gaza Strip. The court further notes that the Attorney General of Israel recently stated that a call for intentional harm to civilians may amount to a criminal offense, including that of incitement, and that several such cases are being examined by Israeli law enforcement authorities. While such steps are to be encouraged, they are insufficient to remove the risk that irreparable prejudice will be caused before the court issues its final decision in the case. In light of the foregoing, the court considers that there is urgency in the sense that there is a real and imminent risk that irreparable prejudice will be caused to the rights found by the court to be plausible before it gives its final decision. The court concludes on the basis of the aforementioned considerations that the conditions required by its statute for it to indicate provisional measures are met. It is therefore necessary, pending its final decision, for the court to indicate certain measures in order to protect the rights claimed by South Africa that the court has found to be plausible. The court recalls that it has the power under its statute, when a request for provisional measures has been made, to indicate measures that are in whole or in part other than those requested. In the present case, having considered the terms of the provisional measures requested by South Africa and the circumstances of the case, the court finds that the measures indicated need not be identical to those requested. The court considers that, with regard to the present situation, Israel must, in accordance with its obligations under the Genocide Convention, in relation to Palestinians in Gaza, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of the Convention, in particular, A, killing members of the group, B, causing serious bodily or mental harm to members of the group, C, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and D, imposing measures intended to prevent births within the group. The court recalls that these acts fall within the scope of Article 2 of the Convention when they are committed with the intent to destroy in whole or in part the group as such. The court further considers that Israel must ensure with immediate effect that its military forces do not commit any of the aforementioned acts. The court is also of the view that Israel must take measures within its power to prevent and punish the direct and public incitement to commit genocide in relation to the members of the Palestinian group in the Gaza Strip. The court further considers that Israel must take immediate and effective measures to enable the provision of urgently needed basic services and humanitarian assistance to address the adverse conditions of life faced by Palestinians in the Gaza Strip. Israel must also take effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of acts within the scope of Article 2 and Article 3 of the Genocide Convention against members of the Palestinian group in the Gaza Strip. Regarding the provisional measure requested by South Africa that Israel must submit a report to the court on all measures taken to give effect to the order, the court recalls that it has the power, reflected in Article 78 of the Rules of Court, to request the parties to provide information on any matter connected with the implementation of any provisional measures it has indicated. In view of the specific provisional measures it has decided to indicate, the court considers that Israel must submit a report to the court on all measures taken to give effect to this order within 1 month as from the date of this order. The report so provided shall then be communicated to South Africa, which shall be given the opportunity to submit to the court its comments thereon. The court recalls that its orders on provisional measures under Article 41 of the statute have binding effect and thus create international legal obligations for any party to whom the provisional measures are addressed. The court reaffirms that the decision given in the present proceedings in no way prejudges the question of the jurisdiction of the court to deal with the merits of the case or any questions related to the admissibility of the application or to the merits themselves. It leaves unaffected the right of the governments of the Republic of South Africa and the State of Israel to submit arguments in respect of these questions. The order then states that the court deems it necessary to emphasize that all parties to the conflict in the Gaza Strip are bound by international humanitarian law. It is gravely concerned about the fate of the hostages abducted during the attack in Israel on 7 October 2023 and held since then by Hamas and other armed groups, and calls for their immediate and unconditional release. I shall now read out the operative part of the order. For these reasons, the court indicates the following provisional measures. 1. By 15 votes to 2, the State of Israel shall, in accordance with its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide in relation to the Palestinians in Gaza, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of the Convention, in particular, A, killing members of the group, B, causing serious bodily or mental harm to members of the group, C, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and D, imposing measures intended to prevent births within the group. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad hoc Moseneke. Against, Judge Sebatinde, Judge Ad hoc Barak. By 15 votes to 2, the State of Israel shall ensure, with immediate effect, that its military does not commit any acts described in point 1 above. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad hoc Moseneke. Against, Judge Sebatinde, Judge Ad hoc Barak. By 16 votes to 1, the State of Israel shall take all measures within its power to prevent and punish the direct and public incitement to commit genocide in relation to members of the Palestinian group in the Gaza Strip. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judges Ad hoc Barak, Moseneke. Against, Judge Sebatinde. By 16 votes to 1, the State of Israel shall take immediate and effective measures to ensure the provision of urgently needed basic services and humanitarian assistance to address the adverse conditions of life faced by Palestinians in the Gaza Strip. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judges Ad hoc Barak, Moseneke. Against, Judge Sebatinde. By 15 votes to 2, the State of Israel shall take effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of acts within the scope of Article 2 and Article 3 of the Convention on the Prevention and Punishment of the Crime of Genocide against members of the Palestinian group in the Gaza Strip. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad hoc Moseneke. Against, Judge Sebatinde, Judge Ad hoc Barak. By 15 votes to 2, the State of Israel shall submit a report to the court on all measures taken to give effect to this order within 1 month as from the date of the order. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad hoc Moseneke. Against, Judge Sabutinde, Judge Ad hoc Barak. I shall now call upon the registrar to read the operative part of the order in French.
Par ces motifs, la Cour indique les mesures conservatoires suivantes. 1. Par 15 voix contre 2, l'État d'Israël doit, conformément aux obligations lui incombant au titre de la Convention pour la prévention et la répression du crime de génocide, prendre toutes les mesures en son pouvoir pour prévenir la commission, à l'encontre des Palestiniens de Gaza, de tout acte entrant dans le champ d'application de l'article 2 de la Convention, en particulier les actes suivants. A. Meurtre de membres du groupe. B. Atteinte grave à l'intégrité physique ou mentale de membres du groupe. C. Soumission intentionnelle du groupe à des conditions d'existence devant entraîner sa destruction physique totale ou partielle. Et D. Mesures visant à entraver les naissances au sein du groupe. Pour Madame Donoghue, présidente, Monsieur Gevorgyan, vice-président, Messieurs Tomka, Abraham, Benouna, Youssouf, Madame Choué, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Monsieur Moseneke, juge ad hoc. Contre, Madame Sebutinde, juge, Monsieur Barak, juge ad hoc. 2. Par 15 voix contre 2, l'État d'Israël doit veiller avec effet immédiat à ce que son armée ne commette aucun des actes visés au point 1 ci-dessus. Pour Madame Donoghue, présidente, Monsieur Gevorgyan, vice-président, Messieurs Tomka, Abraham, Benouna, Youssouf, Madame Choué, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Monsieur Moseneke, juge ad hoc. Contre, Madame Sebutinde, des juges, Monsieur Barak, juge ad hoc. 3. Par 16 voix contre 1, l'État d'Israël doit prendre toutes les mesures en son pouvoir pour prévenir et punir l'incitation directe et publique à commettre le génocide à l'encontre des membres du groupe des Palestiniens de la bande de Gaza. Pour Madame Donoghue, présidente, Monsieur Gevorgyan, vice-président, Messieurs Tomka, Abraham, Benouna, Youssouf, Madame Choué, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Bran, juge, Messieurs Barak, Moseneke, juge ad hoc, contre Madame Sebutinde, juge. 4. Par 16 voix contre 1, l'État d'Israël doit prendre sans délai des mesures effectives pour permettre la fourniture des services de base et de l'aide humanitaire requis de toute urgence afin de remédier aux difficiles conditions d'existence auxquelles sont soumis les Palestiniens de la bande de Gaza. Pour Madame Donoghue, présidente, Monsieur Gevorgyan, vice-président, Messieurs Tomka, Abraham, Benouna, Youssouf, Madame Choué, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Messieurs Barak, Moseneke, juge ad hoc. Contre, Madame Sebutinde, juge. 5. Par 15 voix contre 2, l'État d'Israël doit prendre des mesures effectives pour prévenir la destruction et assurer la conservation des éléments de preuve relatifs aux allégations d'actes entrant dans le champ d'application des articles 2 et 3 de la Convention pour la prévention et la répression du crime de génocide commis contre les membres du groupe des Palestiniens de la bande de Gaza. Madame Donoghue, présidente, Monsieur...
It's likely my audience doesn't speak French. The court has made some important moves today, and this is incredibly important. And again, I bring you back to the live coverage as soon as we get something new going, or as soon as it goes back to English. I will make sure you get wall-to-wall coverage. But it's important to understand that the ICJ's decision today, its order is probably a better way to put it, is not a decision about genocide. It's not a decision about, it's not a finding of fact that Israel has committed genocide. But it is a finding of something. And I don't want you all to think that this was a small matter. This was absolutely not a small matter. the first thing that the court did, it was a lot. I know it's been a lot. It's been almost an hour. I'll tell you what the court did. I'll tell you what the court didn't do. The first thing is the determination of what a dispute is. They made a legal argument for what constitutes a dispute, and they ultimately said that there is a dispute between Israel and South Africa, and that then means that a review of the case's merits is warranted. The reason why this is important, and I think we see the court here taking a quick break. Let me just check back in. I just want to, again, live coverage is different. Yeah, it looked like they filing out of this, John. But what the court said is, and we missed the piece of the coverage. I'll check in right now and find out whether they adjourned or not, whether this is a recess. But what it looks like is an adjournment. I can't imagine that there's more. But yeah, the court has adjourned. So I'll give you the quick update because I think it's important. So first thing they did was they made a case for there being a dispute. The reason why this was important was because the initial Israeli argument, the initial Israeli case that was made was that there is no dispute. Not to say that South Africa didn't have an issue, but at the level of a legal dispute, they said that there was no dispute. And part of how they made that argument for the absence of a dispute was by making the argument that Israel had not been given proper notification, and that they had not been made party to an opportunity for certain types of communication that would allow them to do so. That was combined with the question of legal standing. Does Israel have the legal standing? Or excuse me, does South Africa had the legal standing to, in this particular matter, to do such? This was the question. The International Court says that they do. Israel also made an argument or raised the question of throwing out the case. Throwing out the case was what Israel had hoped for. And if you remember in the previous video that I made maybe a week or two ago, one of the questions was, could the case be thrown out for issues of standing? One of the questions always is about one's status as a state. But if you remember, in 2010, we had a similar issue with Myanmar. And even though Myanmar was not a state party, there were other issues that made it admissible. And then we saw the same with the ICJ with regard to Myanmar. So what that means is with the Myanmar precedent, with regard to Gambia, there was a sufficient precedent. I'm sorry, I'm reading the updates as we go. Forgive me for talking so slowly. So there's two things. I'm sorry. There's two things here. There's the 2010 issue around being party to the Rome Statute. Then there's just double checking here. Yeah. Then there's also the ICJ 2 years ago, almost a year and a half ago, rejected Myanmar's preliminary objections to the case brought by Gambia under the International Genocide Convention for what Myanmar was doing to the Rohingya population and focus on their military operations. Excuse me. I'm reading this in Arabic, so I'm doing it like two things at the same time. Forgive me. So let's go there. The next thing that the court just did, because I want to give you all the updates here, is that the question was, is there a plausible risk of Israel committing genocide? That became the next question. Is there a plausible risk of Israel committing genocide? This was the question. the court is not making a case that Israel has committed genocide. That's important to note. The court is not saying that Israel has committed genocide. The question was, is there a plausible risk of Israel committing genocide in Gaza? It's like a preliminary hearing. You know, are the facts strong enough to move forward? Are they weak enough that we can dismiss them? The court said these facts are not weak. These facts are strong. The evidence is strong. And so they went from there. All right. So they confirmed jurisdiction. And honestly, the tone from the court, I would say, was very. If I were South Africa, I would be very encouraged by what happened. We're going to get to Uganda, y'all. I see a lot of Uganda commentary, and I understand why. We're going to talk about that. The court also began to invoke statements by Israeli ministers. Now, if you remember before, or Israeli leaders, and the reason why this was important was because there's both the question of legal standing, there's a question of the facts, and there's also not just the practice of genocide, but conspiracy to commit genocide, the intent to kill genocide. There's the mens rea, right? The question of whether or not there is a guilty mind at play here. And the court read the statements. The court read the statements from various Israeli leaders about genocide, about what they were going to do to the Gazans, about what they were going to do to Hamas, which is also important because Israel made two very interesting and important claims. One I thought was a pretty compelling argument, which was the people saying the most genocidal stuff ostensibly were not members of the war cabinet. They weren't members of necessarily even the Knesset. So yeah, if a random politician or a former prime minister or an angry person gets upset and starts saying wild stuff about what they're going to do to Palestinians, even if you think it's wrong, they don't have any influence over the Israeli military apparatus, and therefore it's not actually genocidal intent. It's just an angry person after the ugliness of October 7th. That's what they were arguing. And so they were saying these statements are, they didn't say inadmissible, but they said that they don't constitute genocide, that they're largely unpersuasive. That was an important argument. The court didn't seem to find that argument persuasive because they damn sure read those very statements. They read statements from Israeli officials. In particular, they read a statement from the Israeli defense minister, which is an important one, right? This isn't a former general. This isn't an angry local, councilman. This isn't the head of the mayor of a settlement. This is the Israeli defense minister announcing that he ordered a complete siege, no fuel, no electricity, no food. And on the following day, he stated, "We are fighting human animals." The ICJ president referenced in the ruling the obscene statements by the president of Israel, not the prime minister, but the president of Israel, and the defense minister. "We are working according to international law. It is an entire nation out there that is not responsible. It is not true about civilians not involved. They could have risen up. They could have made a coup d'etat." In other words, showing that Israel is targeting civilians, that they are not simply having a targeted Hamas mission, which is also important because, and that's the second point that the court did with regard to this matter, and that is that they pointed to statements that Israel made about getting at Hamas, because it was very clear that while Israel was saying Hamas, they were also suggesting that all citizens, every one of them, is complicit and may even be Hamas. This was Israel's not so subtle message. And then, of course, the Minister of Energy, who said all the civilian populations ordered to leave immediately. They will not receive a drop of water until they leave the world. The world. Not the region even, which would just be ethnic cleansing, depopulation, transfer, all these other war crimes, but the world. So that became important. The ICJ president also pointed out that the court has jurisdiction to issue emergency orders in the genocide case, right? A link exists between the rights claimed by South Africa that the court finds to be plausible. It's important stuff. It's important stuff. It's crazy that mainstream media didn't cover it. The court considers the catastrophic humanitarian situation in the Gaza Strip is at serious risk of deteriorating before the court renders its final judgment. So this is an important point that the court made, because this ruling was about the emergency order. And what they were saying is we have to issue emergency order. The court had to make the case for why there was an emergency order. And the reason why there was a need for an emergency order is they're saying, based on what's happening, if we wait for the final verdict, if we wait until there's a determination of genocide, things could get so bad there. I mean, in theory, everyone could be dead, everyone could be evacuated, everyone could be transferred, right? It's urgent and necessary for there to be an emergency order. That's what the court is saying based on what Israel is doing. And so they said, the court considers that there's urgency. The court concludes that the conditions required by its statute for it to indicate provisional measures are met. It is necessary for the court to indicate certain measures. It has the power under its statute to indicate measures that are in whole or in part other than those requested. Israel must, in accordance with its obligations under the Genocide Convention, take all measures to prevent killing members of the group, causing serious or bodily harm to the group, and imposing measures intended to prevent births within the group. In other words, you have to stop. Now, this wasn't a ceasefire, because I know some people are asking that. They did not go as far as to ask for a ceasefire. I will get there too. But they did say that you have to stop. That Israel has to undertake all measures possible. Now, this is an important public statement to make. It's an important claim to assert. The problem is international law already says that. The conventions against genocide already say that. Shit, Anthony Blinken said that. The U.S. Secretary of State said that part, right? As did the Secretary of Defense. Hey, y'all, really try not to kill people who don't deserve to be killed. And that's kind of everybody except combatants. And Israel just doesn't say no. They just keep saying, yeah, that's what we're doing. And then they keep on doing business as usual. I'm saying that to say that it's not entirely clear how this ruling is going to change Israel's measures in practice. Israel's already said we're not going to listen to the ICJ. We're not going to respond to the ICJ. And so therefore, you know, whatever, basically, nothing will stop us from battling Hamas was Netanyahu's argument. And so what they're going to say is we're still doing the same thing. We're not going to attack anybody. We're not going to kill anybody. We're not going to genocide anybody. We're just going to go after Hamas, and that's all we're doing. This is incidental contact, as they say in sports, you know. So it's not entirely clear how in practice this is going to be much different. But we'll see. They've also asked Israel to issue a report. They say the court considers that Israel must submit a report to the court on all emergency measures taken with effect of this order within 1 month. So Israel has to make a case for or a report making a case that it has taken emergency measures. In other words, what have you done different? You know, it's like, you know, it's like, what have you done different? And then they say that the order states that the court deems it necessary to emphasize that all parties in the Gaza Strip, or that all parties in the Gaza Strip are bound by international law. It is gravely concerned about the fate of the hostages abducted on October 7th and calls for their immediate and unconditional release. It's an important point too now. Can't ignore that. They have called for the release of hostages. There's no court of law, domestic or international, that will allow or justify or sanction or even just not ignore the taking of hostages. And they will all demand for the immediate and unconditional release of all hostages. Hostages are different than prisoners of war. And so by a vote of 15-2, we'll talk about that too. The states of Israel shall take all measures within its power to prevent the commission of all acts, killing members of the group, causing serious bodily or member harm, deliberately inflicting conditions of life calculated to bring about its physical destruction, and imposing measures intended to prevent births within the group. In other words, they're saying by 15-2, they're saying, Israel, you have to stop committing genocide. I mean, that's literally what, I mean, literally all those conditions are the description of acts of genocide. And then by vote of 16-1, the state of Israel shall take immediate measures to ensure the provision of basic services and humanitarian assistance. So only one group, only one country voted no to taking immediate measures to ensure the provision of basic services and humanitarian assistance. I think you know what judge that was. We'll get into that. By 15-2, the states of Israel shall take effective measures to prevent the destruction of evidence related to the crime of genocide against the Palestinian people. Again, seems like a no-brainer. Now, of course, one of the judges is from Israel. Sort of makes sense that they wouldn't disagree with their own country. But Judge Sebutinde from Uganda, can someone explain Judge Sebutinde from Uganda for me? I don't say that with any malice or anger or shame or frustration. Just downright confusion. Just outright confusion. I don't know. So the next piece of this is, did Israel receive a ceasefire order? Did they receive a stop the siege order? No, they did not. They didn't. But what they did do was say, take all emergency measures to make sure people are okay and to stop doing harm. A reasonable person, I know we're talking crazy talk here. We talk about nations and war and reason. Yeah, let me address a comment here because I think it is important. The person says they did not say Israel has to stop committing genocide. That's a falsehood. They say Israel shall not do such and such. They never ruled that Israel did any of those things. So to be clear, I began this commentary by saying that no findings of fact have been made. They didn't say that Israel was guilty of genocide. They said that it's plausible, that there's a plausible argument that Israel may have committed acts of genocide, and as such, the case will move forward. And what I said is, they listed 4 things that Israel should not do, that Israel shall not do such and such. And the things that they said are literally the points that constitute genocide. In other words, they didn't say Israel was ordered to stop robbing banks. You're right. They said that there's a plausible case that Israel could have robbed a bank, and we're going to move the case forward. But in the meantime, Israel is not to walk into banks with guns and masks and ask and demand money. That's effectively what they said. So they didn't say stop doing it. What they said is you cannot do it. And that's the point that I'm making. And so, because all the points that they listed, again, were points that are from the international conventions against genocide, the Geneva Conventions, the Hague, all of it. And so that's the point that I'm making. So they didn't make it now, but again, a reasonable person would interpret all the emergency orders as a call to not commit genocide. The problem is that Israel's legal defense is that we're not committing genocide. Israel's legal defense is that we are simply trying to protect ourselves, that we're exercising self-defense, and that we're only targeting groups of combatants, and specifically Hamas. And so Israel will say, we're already doing what the court said. This is a waste of our time. And there's no enforceability here, right? That's the real crisis. It's 2 problems, right? Nightskin kind of hit the nail on the head on it. It's a toothless ruling, but it's also an insufficient one slightly. They could have called for a ceasefire. And in the absence of calling for a ceasefire, which they may feel like is out of the purview or jurisdiction of the court. I don't know. I'd love to know why they did not. But what we do know is that they're saying that y'all have, again, to use the bank robbery metaphor, they're saying we got you on tape in a bank. We can see your face. We're not finding you guilty, but we're saying there's enough evidence here to move this thing forward. The court clearly sees that, but that's all they can do. I mean, they could even calling for a ceasefire, as much as that would have been great for a political purpose, and it would have been great to advance the narrative, a very accurate narrative, that Israel's in the minority. I mean, even the ruling 15-2, 16-1 suggests that everyone that this is prima facie an act of genocide. To me, that's what this would help reinforce, and the ceasefire would absolutely do that. But they didn't go ceasefire, but they did everything short of a ceasefire. They did everything short of a ceasefire. And the fact that it's everything short of a ceasefire is very, very encouraging. Ceasefire would be more encouraging, to be clear, but everything short of a ceasefire is still pretty solid work. Now, Smith JS says the Zionist mental gymnastics are going to be spectacular. I mean, what they're going to say quite clearly is the court's anti-Semitic, that the world doesn't want Israel to defend itself, that they have a problem with the only Jewish state defending itself. Thank you, Ahmed Al-Baiti. Thank you, your obvious enemy. I appreciate you. Thank you, With Our Eyes Rise. I'll check out your web link for sure. Abdullah Alush, thank you for joining the channel and becoming a member. And of course, Kanan El-Hajj, thank you so much. It's my pleasure to break this down. They're going to say, Israel's going to say that we're the most moral and disciplined army in the world, and that there's nothing else we can do. We're not going to allow Hamas to kill us. We're not going to allow ourselves to be destroyed, and we can't just stop that a ceasefire will cause Hamas to reemerge in power. The problem with those arguments is, one, they're just not true, right? They're obviously not the more moral army, the most moral army in the world. ICJ is the legal arm of Hamas. Now, that was one of the court's arguments, Apocalypse. Yeah, I'm gonna read your comment. You want to pay $2 to say something dumb? You're welcome to. The court seemed to disregard that. The ICJ is not a legal arm of everybody who disagrees with you isn't Hamas. I mean, that's literally the argument. Oh, you're Hamas. Oh, you think we did something wrong? It must be Hamas. Oh, you don't want us to blow up refugee camps? You must be Hamas. Oh, wait a minute. You destroyed every university in the Gaza Strip? Oh man, that's wrong. Oh, it's wrong. You must be Hamas. Oh, okay. I apologize. Apocalypse is being sarcastic. We get trolled here, so you gotta make that clear. You better put a JK or something, family, because my apologies, Apocalypse, because people do pay and leave really dumbass comments all the time. And the amount of trolling that comes up on this joint, you have no idea. My apologies, Apocalypse. My sincere apology. You have no idea what we be getting over here. But yeah, but literally that is going to be the Israeli arguments that you're Hamas, you're anti-Semitic, you're wrong. You don't want because we're gonna say you don't want us to defend ourselves. If we don't defend ourselves, then we die. If we die, then you're supporting the genocide of the Jews, and therefore you are an anti-Semite. And so there's very little space to have the conversation that needs to be had right now, which is not, are you a Hamas supporter if you agree with the ICJ? Because the goalpost keeps moving, right? The goalpost keeps moving. First, it's a libel. you're making a libel against Israel. You're making things up. You're saying things that aren't true. So then you take it to court. And then the court rules that what Israel is doing is wrong. And then they say, well, the court's anti-Semitic. If you support that court decision, then you're an anti-Semitic. So now the goalpost is moved. So it's like, at what point do you get to make a critique, right? There's a legal argument that's been substantiated so far. Again, they haven't made a ruling against Israel. They've simply said that there's a prima facie case that can be made, that can be moved forward. So I want to reiterate that over and over again, because I don't want to suggest that Israel's been found guilty. They have not. What they have been found is the evidence is compelling enough that they've been given an emergency order to stop what they're doing so that they don't kill everybody. This is tough, man. I'm gonna leave y'all alone, but I just wanted to say, today is ultimately a successful, or encouraging rather, day. If the court had said that South Africa doesn't have the standing, that would have been a disaster. If the court had said that there's no dispute at the legal level, that would have been a disaster. If the court had said that there's no evidence sufficient for an emergency order, that would be a disaster. If the court had said, you know what, there might be, but we just trust Israel to do the right thing, which they didn't. They asked for reports, that would be a disaster. They did the best they could minus the ceasefire order. As a practical matter, I'm not sure that that'll make a difference, because Israel wasn't going to abide by a ceasefire order anyway. So at the end of the day, this is as strong a victory as you're going to see. This is as compelling an argument as you're going to see. From South Africa, I'm talking about. This is as favorable as a response to the argument as you're going to see from the court. And so while a ceasefire order would be great for political momentum, and it would give maybe the UK and Germany and United States more evidence, more of an excuse to be able to challenge Israel in a way that they're clearly scared to do otherwise. And in that sense, yeah, it would be better. Otherwise, it's all the same. I'm not sure they could do anything different, as Charisma says. I'm happy with today. I am happy with today. Mike is right. This is an absolute victory for South Africa. Well done, and thank you. And this goes to the final piece of this, the most important piece, not the most important, but one of the most important pieces of this for me, which is, again, people talk about the lack of global solidarity. But right now, we're having this conversation because an African nation, a global South nation, has stood up, spoken out, and used its own legacy and history of apartheid as a form of moral authority to say, we know what this is, and we're not going to allow it. The opposite of the Germany approach. Germany has said, we have committed genocide. We have been an apartheid nation. We have been a violent nation. And our way of recouping our moral authority is to allow the people who we harmed to now become wounded hurters rather than wounded healers. Apartheid in South Africa, their response has been different. They said, yes, we did harm in the past, and our way of making it right is to make sure that no one else does it again. That's something else. Thank you, Nick Baruti. Nick Baruti, are you Nick Baruti from Philadelphia? Are you Nick Baruti I went to middle school with? Are you Nick Baruti, the Lebanese friend of mine from distant elementary school in 1990? That would be crazy if it is. If it's not, it's still cool. Thank you so much either way. So we have to be encouraged by that. To me, the victory is not just in the outcome. To me, the victory is also in how it came about. But there's a lot more work to be done. The organizing and the activism on the ground has to be intensified. This ruling doesn't actually change anything on the ground. Right now, 1% of the child population of Gaza has been killed. More than 10,000 Gazan children have been killed. Right now, the death toll is at 26,000 almost, with 8,000 people still under the rubble. Right now, Palestinian mothers and children, Palestinian mothers are being killed every hour, a Palestinian mother is being killed every 2 hours, excuse me. Part of genocide is preventing future births. Killing babies and women prevents future births. All of these things are happening. Louis Malone, thank you so much, my brother, for gifting people 5 memberships. That is a blessing. Thank you. I'm so grateful. In this context, genocide is happening, and you can't bring people back. You can't bring people back. And so if you can't bring people back and the genocide is expanding, then the ICJ ruling is encouraging, it's powerful, but it doesn't stop genocide. What we have to do, though, is use the ICJ argument and the ICJ decision right now as an energy builder to remind people, for people who are on the fence and saying, well, it seems like Israel's just defending itself. It seems like Israel is just protecting its interests. It seems like Israel is doing the right thing. This is when you say, okay, well, not only is that not true based on human rights organizations, not only is that not true based on the accounts of journalists, those who are allowed in there and who haven't been killed, but now the most powerful international court has made a similar determination. The ICC will make its own determinations, right? But that's about wartime, and that's a little more complicated when we talk about the Rome Statute and Israel not being party to it. And then we got to think about what's next, right? Like, now that we have the legal, the media, the scholars, the activists, the human rights organizations, they're all saying the same thing. Now we can make a case. Now we can make a case, a bigger case, a tougher case. And Litha is right. She's raising the question. She said, I don't understand how this plays out practically. Practically, I think the best case scenario is what Nightskinned is saying, that, and what I said as well, which is that hopefully it gives the West political cover to condemn Israel and stop funding genocide. Privately, from what my sources tell me, and the State Department has been against this. They want this. They want a ceasefire. They want the violence to stop. But they're so afraid of upsetting Israel. They're so afraid of showing an inch of daylight between themselves and Israel. They're so afraid of that they won't do it publicly. But now they can say, thank you, Apocalypse. Now they can say with some legal authority, because they damn sure ain't got no moral authority. They can now say, hey, we have a good reason. We have a good reason to step up and say, Israel, you got to stop this. Now they can be even more public. Now that's the best case scenario. Now, will that happen? I don't think so. Could that happen? Possibly. I mean, it could happen, but I don't think it will happen. This is an uphill fight. Colonizers never say, hey, we're colonizers. Genocide nations never say, hey, you know what? We are committing genocide. So Israel's not going to do it on its own. But if we can organize and struggle together globally, as South Africa just taught us, combined with the fact in the United States that there's an election year, and now voters and organizers can go to Joe Biden and say, hey, the international court has said this. The UN Security Council is about to say something, I promise you. At Davos, the nations are saying economically this is unsustainable. The human rights organizations are saying this, that maybe, just maybe, there's space for somebody to say something and do something different. There has to be. There has to be. There has to be room for something different, y'all. Yeah, that's the most encouraging thing that we can see. We all know that international law is important. As activists, it's what we appeal to. As organizers, what we point to say, that's wrong. Look, this is illegal. You can't do that. But international law rarely compels people to move differently. It rarely stops despots from despoting. Zaya Qureshi, shukran katir, shukran katir. It rarely actually works. But what it can do is, again, give us space to do certain kinds of work. And that's what we're hoping for at best. Anyway, y'all, I don't want to keep y'all all morning. I know we have a lot going on here. I'm going to take just a couple quick questions and then we're out of here. Ashfields writes in and says, aren't you disappointed there was no call for a ceasefire? Seems like they're making the same mistake like they did for the Bosnian genocide, where they didn't call for a ceasefire back then. Absolutely. 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 1000%. 1000% correct. You have said nothing wrong. The problem, Ashfields, is that, let me say this, disappointment suggests an expectation that I thought it was going to be this and I was let down. I'm not let down by this. I didn't necessarily expect a ceasefire. I hoped for a call for a ceasefire. I definitely thought it was possible. If you'd asked me, I would have said they're going to do 9 of these 10 things, I would say with 90% certainty. I felt good about. My slight fear was that they would say that there was a jurisdictional or standing issue. But outside of that, I knew if they had standing, South Africa made a hell of a case. I wasn't worried about that at all. But the one issue that I was worried about was whether they call for a ceasefire. And the reason is they could make, actually, you know what? I don't know why. I mean, the best argument Israel can make for why a ceasefire is impossible is that Hamas is still active in trying to kill them. Hamas has been very clear in saying, though, that they support a ceasefire and that they would abide by a ceasefire if the ICJ ruled as such. And whatever you think about Hamas, they pretty much kind of, I have every reason to believe that they would have followed it, even if it's just for their own interests. So it would have been shocking to me if it had gone differently. It would have been shocking to me if it had gone differently. All that said, the lack of a ceasefire, to get back to your question, the lack of a ceasefire was not disappointing because I didn't expect it. But the small part of me that hoped for it, it's like, yo, we could do something different, because the Bosnian genocide is actually an incredibly interesting and compelling, case. It's an interesting and a compelling case. And I don't know how to I don't know how to think about this working without a call for a ceasefire. And I don't know how to think about a ceasefire without there being teeth, legal teeth, diplomatic teeth, economic teeth, political teeth. And the teeth don't come from the court calling for the ceasefire. Again, it's a great political strategy. It's a great message. It sends all kinds. It gives the Biden administration, among others, the Macron administration. It gives everybody the permission to be courageous, right? It does. But at the end of the day, you don't need an international court. You don't need an international court. to make Israel have a ceasefire. What you need is, thank you, Rusty, what you need is the United States to stop giving them weapons. What you need is to stop giving $3 or $4 billion of military aid. What you need is to stop proposing $6 to $8 million more in military aid, emergency military aid. What you need to do is stop shielding them at the UN Security Council. What you need to do is stop suggesting that this is a righteous war and giving political cover publicly to this. What you need to do is stop funding the defense systems that not only allow Israel to protect itself, but to have what's called a qualitative military edge. So this is, if you do those things, Israel can't win. If you don't give Israel money and guns and political protection, they can't win anyway. You can't have a ceasefire if you don't have no fire. And the fire is coming from the United States. So the ICJ is important, but the United States is the key. The US is, as to quote the great Reggie Jackson, is the straw that stirs that drink. Now, there's also, in Indonesia, I'm not an expert on Indonesia, but yes, they are supposed to be taking Israel to the ICJ from what I've heard. But what I've also heard, John Smith, is that other nations are taking, other nations are being taken to the ICJ. The United States can and should be taken to International Court of Justice. The United States should be taken to the International Court of Justice for complicity in genocide. If the United States, after today, after this ruling, still continues to give money and guns and political coverage to Israel, how could it not be seen as complicit? When the American media apparatus continues to lie and say that Israel is attacking hospitals because Hamas has command centers under there, if they continue to perpetuate the war machine and cause more unnecessary death, are they complicit? This is a question we got to ask. These are the questions we got to ask. We got to be courageous here. We got to be courageous here. Because if those are the cases, if that's the case, my God, the ICJ gonna have a full docket, family. The ICJ gonna have a full docket. Mike Amin said, I'm disappointed in Harvard. I don't know what you expected, Mike. Highly favored says Israel has to submit monthly reports. Is that not a way, an indirect way of a ceasefire? That's a great question. It is a direct way of saying Israel needs to do something different. They're saying that you have to make it very clear what you're doing to avoid civilian casualties and what you're doing to avoid all the things that make this a genocide. The problem is Israel is going to do what it's been doing, which is say either one, we don't give a damn what the ICJ says, or two, and not submit the reports. Or they're going to say, same thing they always say, oh yeah, we went to Al-Shifa Hospital and we had to blow it up because there was a Hamas command center under there. But we gave people notice. Yeah, we told people in Khan Yunis to go from Khan Yunis to the south. We did that. That's what we're supposed to do, right? The problem is not just in the reports, because the reports will give the strategy. The question is, can we trust the Israeli account when they have repeatedly given an account that's different than what other people are saying on the ground? So I'll give you a very specific example. If they were to blow up another hospital, Indonesia hospital, Al Ahli hospital, Khan Al Shifa, if they were to bomb it, for example, again, what they would say is, well, we took all reasonable precautions to prevent that. We moved people out and we did X, Y, and Z. The problem with that approach is that what we found on the ground is that people have been told that even the humanitarian corridors or even the safe pathways have been bombed. We saw that with Hamza who was killed on a journalistic safe route. Or they'll say we only bombed where we had reasonable intelligence that there was a Hamas command center. And then you dig up there and you look and you see some old dates, 3 pairs of handcuffs, and a VHS cassette tape, and maybe some shit and a little bit of weaponry, but certainly nothing that looks like a command center. I'm not exaggerating. Check the video I posted from last week about the New York Times account, about how the New York Times gave this ridiculous account of underground tunnels in Gaza. And so yes, they have to fill out the reports, and yes, the reports are made to show how they're avoiding casualties. And if they don't submit the reports, and if they don't submit the information accurately, then yeah, they could be in contempt. But again, what's the penalty? But it's more likely that they may ignore it, but they also may submit them and keep saying what they've been saying, which is not that helpful. Now, what you could then do, again, is charge them again and show and a command pass انا كمان خصوصا هلا يعني انا جوعان. um and so there's a very complicated web here, in terms of them complying and then them telling the truth. And then if they comply and tell the truth, even if it's their truth, even if they believe it, which is ridiculous, then what do you do? Then you have to make another case. And then there's the ICJ argument, ICC argument, right? Which is about the ICC argument, which is, are these also war crimes? And does the fact that the ICJ given an emergency order to say stop it and they continue to go, does that now intensify the case in the ICC? And of course, some of you are going to say, well, they're not party to the ICC because Israel's not party to the Rome Statute because they didn't want to be. But they can still be investigated because Hamas is in Palestine is party to the Rome Statute. They are party to the ICC. And so what happened in Israel would not be, but what happened in Gaza would be. And since Israel's actions are in Gaza, Israel is investigatable because of their crimes in Gaza. That makes sense? And that's what I was told by the UN High Commission, the UN High Commissioner on this matter. So this is not my personal belief. It's what human rights and legal experts have told me. Ms. Hoops Lover said, how does this ruling impact the U.S. with supporting Israel? That's the question that remains to be seen. That's the $1 million question. I don't think it changes the U.S.'s relationship at all or their support. But what they might say, what they might be able to publicly do now is say, we support the ICJ's call for reports. We want to make sure, and what they're going to say is Israel's doing nothing wrong, and they're going to give reports and comply with the court to prove it. That's what they're going to say. That's the language they're going to use, which sort of makes sense strategically. Rasti Amin says, feels like Israel's going after Gaza oil and gas reserves, hence the buffer zone. What do you think? I don't know. I don't know if it's about oil and gas. I think it's about ultimately ethnic cleansing. I think ultimately, at the end of the day, Israel wants control over all of historic Palestine. Netanyahu last week made it very clear that he has no intention of allowing a Palestinian state at all, that the two-state solution isn't even an illusion anymore. It's not even a two-state illusion anymore. And so, and the argument is safety and security that we've learned from all of this, that Israel cannot have a state next to it that is a Palestinian state, because they'll keep making Hamas their leaders, and they'll keep allowing Hezbollah to come down and be controlled through it vis-a-vis Iran. Hamas and Hezbollah have Iran moving the puppet strings, and we can't have Iran because they near us, because they are an existential threat to us, and therefore we need to have security control over everything west of the Jordan River. That's their argument. They're literally saying we want to control everything from the river to the sea. I know I'm not allowed to say that. I know Rashida Tlaib is not allowed to say that. I know Palestinians aren't allowed to say that. I know Black activists aren't allowed to say that. But Netanyahu has effectively said he wants everything from the river to the sea. And yeah, he didn't literally say that in a quote, but what he said is we want everything west of the Jordan River. Well, guess what? Guess what's west of the Jordan River? Or of Jordan, excuse me. Guess what's west of Jordan? The West Bank, right? The West Bank of the Jordan River, all of Israel, Gaza. And the only thing that's not in that thing that's part of historic Palestine is what? The Golan Heights, which is already under control by Israel, and the border of Lebanon. So what are we talking here? Welcome, Hallie. Welcome, Logan. Thank you for joining the channel. So this isn't new information. And you're right, M. Adams, he said it explicitly in Hebrew. That's been the narrative for 20 years now. In English, he says, I want a two-state solution. In Hebrew, he says they'll never get to their own state. When he campaigns for prime minister, which is like every week, he's like, I'll never allow them to have a state. In English, he says, we are part of the we're part of the commitment to creating, giving Palestinians what they deserve. أشرف شكرا كثير. أنا بحبكم كمان. بحب أردن وبحب أهل عمان، خصوصا أنا كنت في عمان في السنة الماضية، وبحب الشعب الأردني وكل الناس في الأردن يعني. شكرا جزيلا، شكرا جزيلا. We are at a moment where the movement for a free Palestine is getting some momentum. We are in a moment where we have an opportunity to leverage these court decisions for something good. But I also want you all, that's the last thing I'm going to say, I really do need to run, and I want you all to run. But there's a book that I want you all to read. And it's an important book. It's by Nora Atakat. I'm going to show you the book, and I'm going to put it up here because I think it's that important. I know it's that important. It's a wonderful book that I've read and had the opportunity to be in dialogue with my sister Nora about. And I want you all to look at it because it, if you don't buy any other book, I always tell you, I don't be buying my books. Buy these books. These books are way more important. I promise you. It's called Justice for Some, Law and the Question of Palestine. And the reason why I point to that book is because it allows us to think about law in a different way. Some of us have given up on international law, right? Because it's like, look, every single thing in the occupation, every single thing in the bombardment of Gaza and siege of Gaza, every single thing in the Nakba, every single thing in the Balfour Declaration, every single thing could be engaged and pointed out as a matter of law and a problem of law. And yet, despite all of that, here we are. But I'm sorry, this thing really wants me to update my. Okay. That's good. That's good. See if I can stop that noise. But what Nora Atakat lets us realize, what she gives us permission to think about, is that international law is valuable to the extent that it can help with our politics, to the extent that it can help us mobilize a political movement. So it's not that international law is some magic beam that falls from the sky that will save us, but that it can be a tactic and a strategy and a tool that can help us move forward. شكرا عبير. درست عربي في الأردن يعني كتير في مدرسة CGE في الدوائر الخامسة. تعرف إذا تسكن في الأردن في محل في مدرسة اسمها CGE في الدوار الخامس في برنامج كويس 100%. وين في تعليقات في كمان تعليقات. There's a lot of Arabic speakers in here. If I'm speaking Arabic, because a lot of the comments that are coming into me are in Arabic and people are asking me questions in Arabic. I'm not just like trying to flex or be a weirdo. It's that the questions are coming in Arabic. Some of them are notes, some of them are comments, some of them are literally written in Arabic script, and so I'm trying to respond to those at the same time. أنا عم بفسر ليش عم بحكي بالعربي. Okay, so at the end of the day, family, we've had an important morning. I'm going to wind this down. We've had an important morning, a necessary morning, a beautiful momentum push that I think we should use as a mechanism, not to believe that victory is inevitable or even that it's close, but that the world is watching, that there's solidarity, and that there's more work to be done. So we'll keep watching, we'll keep studying. Stay here on the channel throughout the day. I'll be doing some other things, of course. We know that Israel's war on Gaza is now at day 112. I'll give you full updates. I'll focus less, obviously, on this court decision since we spent the last 2 hours doing that. But I will give you full updates on everything that's been going on in the court. And also what's been going on the ground, the losses, the deaths, the diplomatic developments. We'll talk about all of it. And there's other stuff going on in the world that we're going to talk about as well today. So stay close to the channel. In the meantime, if you've been watching this stream, hit the like button. If you've been watching this stream, hit the subscribe button. If you've been watching this stream, hit the join button. There's a button that says join that will allow you to become a member of the Marc Lamont Hill official YouTube channel. And when you do that, when you join the channel, it allows us to build infrastructure to be able to do things like have a live stream of the ICJ decision. It allows us to have a team of producers and a group of people who do fact checks, who produce videos for us, who do all these different things. And so joining becomes a great thing. And of course, if you're so inclined and you support the work of the channel here and the work that we're doing, not just to free Palestine, but the work we do to give independent radical politics a voice, do a Cash App. Hit the $ MLHTV and drop something in. If everybody right now dropped $5, we would be able to build 10 new videos with a whole team of people. If everybody here dropped $10, we'd be able to make significant headway in getting a studio space that would allow us to do a daily or weekly a television show. This is the work. So if you can, and if everybody just drops $1, we're able to pay editors and producers. So whatever you can do, we're grateful for. Whatever you do, we appreciate. Riaz Guerra, thank you so much. Thank you so much for your support. Thank you so much for that generous donation. But anyway, family, if you can't drop anything in, that's okay too. We're not here for money. We're here to do the work. So if you can't do anything else, just hit like and let YouTube know that this page matters to you. Hit the subscribe button. It doesn't cost you $1. It allows us to extend our reach and build what we do. I'm grateful to you all. Thank you for watching, and I'll talk to you again soon. Peace.